Welcome everyone to today's webinar on how to protect your home and life savings. My name is attorney Holly Geerdes, and I am the founder of Geerdes and Associates. We are a national law firm with offices in multiple states, specializing in estate planning, elder law, and asset protection. So let's go over the schedule today. First, we're going to discover the 3 steps to plan and protect your home and life savings. Then we're going to create an action plan of how do you actually protect your home and life savings and everything you own. Then we're going to conclude with a brief polling of how you like the webinar. And then we will open it up for a brief question and answer. Now let's go over the topics that we're going to cover today. What are the most common questions that people have asked me in the last 21 years? I have seen it all and I've done it all when it comes to protecting my clients' assets. The most common question is, how do I protect everything that I own? And who are we trying to protect our assets from? Well, from the predators. And when I refer to predators today, I am referring to creditors, lawsuits, divorces, remarriages, the government, probate, the IRS, Medicaid, sometimes your own family. Then we're going to learn what is a trust. All trust is not the same. There are many different types of trust for different purposes. What are the many different types of revocable trust, and what are the different types of irrevocable trust? And then we're going to learn what probate is when you don't do a trust. What is the legal government process called probate court? And how do we avoid probate court from taking over our assets when we die or become mentally incompetent? And then we're going to learn what are the different ways to transfer our assets to our loved ones when we die, instead of just the one generic way, everything to my loved ones with no protection whatsoever. And then we're also going to learn these ancillary documents called financial power of attorney, medical power of attorney, living will. These are additional documents you generally should be signing when you do a will or a trust package. We're going to learn what the risk and the benefits of these documents are when you sign them, when you do a will or a trust package. And then how do we avoid the estate tax? See, when you die, the government totals up everything you own. And if you have a certain amount of assets, the government can tax you as high as 40% of your assets. So obviously, how do we avoid this estate tax? So let's begin with the 3 steps to plan and protect your home and life savings. First, you got to know what the rules and the law is regarding your assets when you're alive and when you are incompetent. Then we got to know who are predators out there that can take away our assets. Again, when I refer to predators, I'm talking about the creditors, the lawsuits, the divorces, remarriages, the government, probate, taxes, Medicaid, sometimes your own family. Anything that can take away your assets when you're alive, after you die for your loved ones, and if you become incompetent. And then finally, what is our options to protect against these predators based on the rules and the law? So let's begin with the rules. 2 simple rules, one when you're alive and one when you're incompetent. Now, most people only think about the rules when they die. Where do we transfer our assets and how do we do it? But the rules when you're alive is equally and sometimes more important to address, Because if you protect your assets when you're alive and you do it right, you will have protected it for everyone that you transfer your assets to upon your death. But if you don't address and prepare for the rules when you're alive, when it comes to protecting your assets, then you haven't protected the assets for you or for any of your loved ones after you die. So let's start with the rules when you're alive. When you're alive and competent and healthy, who controls your assets? Obviously, you do. But what about when you're alive and you get sick and mentally incompetent, mentally unable to make decisions for yourself? What if you have a stroke? What if you're in a coma? What if you have dementia or Alzheimer's? What about all these questions related to your elderly parents? Who controls the assets when that event happens? Just because you're a spouse or a child or parent doesn't give you legal rights over your family member's assets if he or she becomes incompetent. I have a spouse, the husband just became incompetent with a stroke, 47 years old, doesn't have legal authority over any of his assets. Can't touch it. So what does she have to do? Because they didn't prepare for this in advance. Well, we have to go to probate court. And they take over the assets in the meantime. They appoint the incompetent family member a guardian to make the daily decisions. They appoint a conservator to make decisions over the assets. The court appoints an attorney court appointed to make the legal decisions. And the court appoints a doctor to determine the incompetency. And my client has to pay for all of that in addition to the attorney fees. And the court may not appoint her as the conservator. It is entirely up to the court. And if the court appoints somebody else, that person will be managing the assets for the rest of the incompetent family member's life and gets percentage fees and or attorney fees for the rest of the incompetent person's life, telling the family member how to manage the assets on behalf of the incompetent family member's life. Even if my client is appointed, the court still supervises her for the rest of her life, and she has to provide an accounting for the rest of her husband's life to the court. She has to get permission from the court for the rest of her husband's life on how to spend the money. How stressful is that? Being supervised by the court for the rest of her husband's life. That is what happens when you don't prepare. Now, what if my client had a financial power of attorney executed prior to her husband's incompetency? Well, what if you have the wrong one? There are different kinds of financial power of attorneys. I can't tell you how many times family members come into my office, give me the financial power of attorney to give them legal authority to hire me to protect the assets on behalf of the incompetent family member's life. But they have the wrong one. So then we still have to go to probate court and go through all of the same legal process. Hopefully, you have the right financial power of attorney that deals with incompetency. But unfortunately, even the right one doesn't generally work with real estate properties, with businesses. And some financial companies prefer you to use their financial power of attorney. So then you still end up going through probate court to get the legal authority. Now we're going to talk about a trust that deals with all of these what ifs. And so when you do a trust with the financial power of attorney, then you never have to go through the probate legal process in the event of incompetency. but you have to do it right with the right expert advice. Now, what about the rules when you die? Where do most people end up with their assets when they die? The most common is the people with no will, and they end up where? In probate court. What happens when you die with no will, no trust? Well, you end up having to go to probate court to get legal title to the deceased or the dead family member's assets. And when that happens, you hire a lawyer, you file a petition with the lawyer, the probate court takes over the assets, freezes it. Everything becomes public, all the assets, all the debt. It takes 1 to 2 years to get through probate court. The average national expense is 5 to 20% of the value of the assets going through probate court. And again, we just talked about what happens if you are incompetent. You may have to go through probate court. You don't have any control of where the assets go. Surviving spouse, you may only get 1/3 to a half. And if you've got assets in multiple states, you got to go through probate court in multiple states. Very expensive, very time consuming, and very stressful and chaotic. Now, what happens if you die with only a will? Well, unfortunately, people have this misconception that when they do a will, it takes care of everything, but it does not. A will can never transfer assets. A will has to be filed with probate court to initiate the probate process. And the same probate legal process happens as we talked about in the no will, no trust situation. The government freezes the assets. Everything becomes publicized. Still takes 1 to 2 years to get through. Still costs 5 to 20% of the value of your assets. You still haven't protected yourself in the event you become mentally incompetent. Still got to go through probate court if you've got assets in multiple states. So what is the difference then between a will and a no will? Well, if nobody objects, because when you have a no will or a will and you end up in probate court, anybody can object to your will. That's the law. And who is going to pay the litigation fees to go through trial and appeal? You're not. So it ends up settling, and the people fighting over your will and your assets decide where your assets go. But if nobody objects and fights over your assets, then the will designates where your assets go after all of the fees are paid going through probate court. Now, if you've got minor children, you designate a guardian in the will. That has nothing to do with your assets. That only designates who you recommend to have custody of your children. No minor children can ever receive assets while they're minors. The probate court takes over any assets that you leave for your minors, including any bank accounts, life insurance, retirement accounts, property, businesses. And then the probate court, when the child turns 18, releases a lump sum cash to the 18-year-old with no guidance, no protection. That's what happens with minor children. Now, if you have a trust, that is different, and we'll talk about that, because then probate court doesn't have to take over assets because they have no jurisdiction over a trust. Now, what happens? Total up everything you own, multiply by no less than 5 to 20% of the value of your assets, and you decide if that's a cost that you want to incur when it can be avoided. And what happens to your assets if they have debt? If you end up going through probate court with no will or just a will? Well, your assets have to be liquidated to pay off all creditors in full. You have a home or investment property or businesses that have debt, have to be liquidated to pay off creditors. So how do we avoid probate court from taking over your assets? Well, if you do a trust document, the probate court has no jurisdiction. Everything remains private. No assets are frozen, no probate expense, no 1 to 2 year delay. If you become incompetent, you designate who's going to manage the assets for your care. If you've got minor children and you die, you designate who's going to manage the assets for the care of your children. You 100% control where your assets go. Nobody can contest or fight over your assets. And if you've got assets in multiple states, you don't have to go through probate court in multiple states. This trust document controls all your assets in the name of this trust, no matter where it is in the United States. And finally, you can protect your assets from creditors and lawsuits and divorces and remarriages and taxes and other family members, Medicaid. If you do the trust right, you maintain it right, and you pick the right type of trust for asset protection. Now we're going to come back to the mechanics of the trust and the different types of trust. But let's talk about these additional documents that you should be signing when you do a will or a trust package. The financial power of attorney is a document that you designate a person to manage your assets if you become mentally incompetent. Instead of who? The probate court. But this document can be very dangerous in the wrong hands. If you sign a check and you give it to me, what's the most I can take from you? Not everything, only what's in your bank account. But if you designate a person as an agent, they can literally take everything that you own. It becomes a super blank check. That's why it's the #1 document used to abuse and take advantage of mentally incompetent people and senior citizens. So when you sign these documents, make sure you get expert advice and make sure that you put the additional protections in there to prevent anybody from taking advantage of you and taking away and stealing your assets legally, because that's what you're giving them permission to do if you don't put the right additional protections in there. Now, the medical power of attorney and living will are documents that you designate a person to make the medical and life and death decisions. If you don't put specific instructions in there, then you leave it up to your family members to fight with each other about what they think you wanted as to your life and death decisions. Everybody thinks they're right, but they have different opinions. So make sure that when they make those life and death decisions, they're merely following your specific instructions instead of what? Fighting and agonizing over what they think is best for you. Now, we went over the rules and the law regarding your assets when you die or become incompetent. Well, who's out there? The predators that can take away your assets. The top 4 categories: the government, long-term care costs, sometimes your own family, and we're always at risk of being sued in the United States. Now, the #1 predator, the government, always waiting for you to procrastinate or make mistakes or don't do anything at all. We talked about probate court intervening and taking over your assets when you die or become incompetent. The government also gets involved when you die related to estate taxes. Some people give away their assets to the government when they die because they didn't do any estate tax planning. Currently, if you have assets above 11 million, you have to pay the government 40% estate tax, the federal government. In the year 2026, it's going to drop down to 5 million or less. If you have assets above 5 million, then you're going to owe the federal government 40% of your assets above 5 million. Some states have an additional estate tax on top of the federal. And that threshold can be 1 million. It can be equally 5 million. So some people have lost 40% of their assets to the federal government, and they've lost, for example, additional 16% to the state of government. Look at Prince, Purple Rain. He lost 40% to the federal government, 16% to the state of Minnesota, and over 20% or more of his assets just by going through the probate litigation process. Most of his assets are just gone, literally. Now, can you avoid this? Of course. You just have to get the right expert advice on how to avoid and minimize the estate tax. Now, what about long-term care cost? Long-term care cost is the #1 financial devastator for senior citizens. The reason is that nursing home currently costs $9,000 to $14,000 a month, depending on the state you reside. Staying at home can be $18,000 or more. Majority of people on Medicaid for government assistance for long-term care costs were not broke. They became broke because of lack of advanced planning, and they ended up having to spend down all their assets first, or Medicaid took all of their assets when they died as reimbursement. 70% of those 65 years or older will end up in a nursing home before they die. The average stay is 3 to 5 years in a nursing home. For those that have dementia, Alzheimer's, stroke, it's over 8 years in a nursing home. What about those that try to qualify for Medicaid or try to avoid probate court and they put their assets in their children's name? That is the stupidest thing you can do. Because what happens if your child gets divorced, sued, disabled, dies before you, has a spouse you don't end up liking, has money problems? You could lose all your assets while you're still alive. And you have shifted capital gains tax to your children that they otherwise could have avoided if you had just done the right type of planning. So don't put assets in your children's name. You're not doing them any favors. Instead, if you had just done it right, you could not only have assets protected for you to avoid probate and even have Medicaid assistance, but also protected for your children after you die and avoid the capital gains tax for you and your children. You see, Medicaid doesn't require you to be broke in order to get that assistance for nursing home or home care. They just require you to do it right. It is very complicated, but the right type of expert attorney like us, you can qualify for Medicaid and still have assets in your control and have it protected for you and your children when you die. You just have to get the right expert advice and do it in advance of the long-term care crisis. Now, how does your spouse become a predator? Well, when you die, people just generally leave everything to their spouse. And when that happens, what if your spouse remarries? Then the new spouse and their children get everything. What if your spouse ends up in a nursing home? Then the nursing home or Medicaid gets everything. What if your surviving spouse gets sued? Then all your assets are taken by the creditors and lawsuits. What if you owe estate tax? Then the government gets 40% of your assets, federal. In some states, an additional 16%. And what about your children? Majority of children use up or lose your assets before they die. It's gone. Your assets didn't even last the generation of your children. They lose it to creditors, lawsuits, divorces, bankruptcy, disability. The number one reason is to divorce. Your assets are not premarital. So what are the options to protect against all these predators for you, for your surviving spouse, and for your children and your descendants? Well, option one is always available. Keep procrastinating. Try to do it yourself, and the government is right there ready to go, probate court. What about long-term care costs? Well, if you're lucky enough to have long-term care insurance, then hopefully that will be sufficient to cover your long-term care expenses. But if you don't qualify or you don't have it, then you have to start considering for yourself or for your elderly parents, the Medicaid asset protection planning, or the asset protection type of trust that we're going to talk about to protect against the predators, including Medicaid. Now, how do we actually protect all your assets? Well, first we create the trust, and you have to pick the right type of trust and tailor it for you and your family. But when you create any trust document, you're the creator, the owner of the asset. You are the beneficiary, the one who benefits from the assets that you put in the trust. And you are the trustee, the one that controls and manages everything in the trust. And when you die, you name an alternate beneficiary, an alternate trustee, generally your spouse and children. Now, when you do the trust, you're not done. Just signing it and notarizing it doesn't mean anything. A lot of times people do those do-it-yourself trust, the fill in the blank. They don't even know what the document means. They make so many mistakes. There's so many drafting errors, but how would you know? All you do is insert your name. And then they don't put anything in the trust anyway. It's a completely worthless document. If you're not going to do the trust right, don't bother doing it at all. If you just sign the document and that's all you do, there's nothing in the trust. Everything is outside the trust, unprotected. So with the right expert advice, you got to retitle all your assets into the trust, and you got to maintain it during your life because your assets change during your life. And if you do it right, then when you die, all your assets automatically, instantly, privately, no further cost, passes to your loved ones, protected. It's so simple and quick in the end versus doing a will or no will or doing the trust wrong and everything goes through probate court. The probate court freezes it to go through the probate process 1 to 2 years. Probate expense of 5 to 20%, people fighting over your assets. It's just much simpler to have it instantly transfer when you die through the trust. Now, what are the different types of categories of trust? These are the top 3 categories. And within each of these categories, there are different types of trust. Now, the revocable trust is the most popular because you can revoke and terminate this trust document at any time. You can amend it. You control everything as a trustee. You can use everything in the trust. You're the owner. You don't need a separate tax ID. We don't register this anywhere. This document is on standby to transfer all your assets in the name of the trust when you die to the people you designate. Now, the irrevocable tax avoidance trust on your right is not that common. It's used by people that have assets above the federal estate tax exemption and or the state exemption amount. So for example, if the exemption amount is 5 million, so people that have assets above 5 million will put assets into this irrevocable tax avoidance trust above 5 million. They'll name the children as a beneficiary. They get a separate tax ID. They name an alternate trustee. You cannot be the trustee. You cannot use the assets in this trust anymore. You cannot amend this document. But when you die, all the assets in here transfer to your loved ones without being subject to the federal and/or state estate tax. Now, how do we get asset protection without having to give up control and access to our assets like the irrevocable tax avoidance trust? Well, the irrevocable asset protection trust is a hybrid trust. It's a trademarked copyright trust. It's a combination of the revocable trust and the irrevocable tax avoidance trust. But because you don't have to worry about the estate tax, you can be the trustee. You can amend the document. You can have indirect access. You don't have to have a separate tax ID or file separate tax returns. And if you get sued or need Medicaid, you put the assets that you want protected from creditors, lawsuits, and Medicaid in the hybrid asset protection trust. And it's protected. Now, any assets that you want to spend personally for your personal bills or for entertainment, you put it in the revocable trust. But any assets that you want to protect, you put in the hybrid asset protection trust. Now let's look at a case study. Pretend Bob Jr. is your husband, your spouse, Jane and Jim are your children. Now, if you just leave the assets to them unprotected outright, just remember, nothing wrong with that. There's no protection from remarriages, divorces, lawsuits, and creditors, and bankruptcy and disability. But you can, in the right type of trust, pass your assets upon your death to your spouse and children, protected from any and all kinds of creditors, lawsuits, divorces, remarriages, estate tax, Medicaid, disability. So think of it like your family vault. You create the vault to protect your assets. And when you die, you pass the key to that vault to your spouse and children, and they're the only ones that can get in and out of your vault that contains your assets. Whether you do a will or a trust, remember, customize it. Get expert advice. You need to understand the documents you're signing as it relates to your assets. And if you do a trust, get expert advice on how to retitle all your assets correctly into the trust. And you got to maintain your trust during your lifetime in order for it to work. We meet with our clients every year to make sure, for free, that their trust is maintained correctly. Now, for those that attend the webinar, you are eligible for a free, private, 1-hour Zoom consultation, whether it's for you or for your family member. After this webinar, for those that indicate that they want a free consultation during the polling that we're going to conduct, then you will get a calendar invite and a follow-up email and phone call verifying that the preset date and time works for you. And so now, during the consultation though, we will talk about what you learned today. We will apply it to your family and your assets and talk about all of your wishes, wants, and concerns, and answer any additional questions. Bring all documents. If you already have a will or a trust, we will review it and explain to you what you have and what it does and doesn't do. And we will recommend solutions that addresses all of your wishes, wants, and concerns to give you peace of mind. And bring all decision makers to the meeting, because there's no point of learning and having the consultation without the people that help you make the decisions. So now I'm going to open it up to polling in the Q&A.